Hi students, welcome to lesson 15 on the U.S. Constitution, our last lesson of the semester. So first let's look at the principles of the U.S. Constitution. There are three main principles that the founding framers of the Constitution wanted to include in it. The first principle was limited government. The U.S. Constitution, especially if we consider it together with the Bill of Rights, more on that later, it spends a lot of time and a lot of space detailing not just what the government can do and must do, but also what it cannot do and must never do. The founders of the Constitution thought that there were certain matters that were fundamentally none of the federal government's business, and in some cases none of the state government's business either. The founders thought that it would be disastrous to people's freedom to put certain things up to a popular vote. For example, if sheep and wolves were living together in a society of 90% wolves and 10% sheep, would it be a good idea for the sheep to put the question of what to have for dinner up to a popular vote? Probably not, because the wolves would just vote to eat all the sheep. The founders of the Constitution would say that the sheep have a fundamental right to life and liberty that cannot be taken away from them, even if it might be popular to do so, in order to, for example, allow the wolves to eat them for dinner. Second main principle in the Constitution was a representative government, not a directly democratic government. The founders also thought that even with constitutional guarantees against government interference in certain matters, common people, especially those who were uneducated at the time, should not be directly trusted to make and enforce laws on their own. Nor did it seem practical to expect average citizens to do this. Ancient Athens could have a direct democracy because most of its citizens were educated and wealthy slave owners who had plenty of free time to devote to running their relatively small and geographically concentrated city government. This was not the case in the new American states. Therefore, the founders insisted on representative government, not direct democracy. And even when it came to choosing representatives, even this choice was not at first open to most adults for most decisions. Only legislators in the House of Representatives were initially chosen by popular vote. In contrast, senators, Supreme Court justices, and even the president were technically appointed, either by state legislators, the president, or the Electoral College, respectively. So senators were appointed by the state governments. The president was technically appointed by the Electoral College, and Supreme Court justices were appointed by the president with the Senate's consent. And, even when it came to electing the House of Representatives, the one place where voters did get a direct say, most states originally only gave the right to vote to white adult men who owned a significant amount of property and who paid a significant amount in taxes. Poor, uneducated, non-white, non-male people were generally excluded from the right to vote at first. Many founders were deeply suspicious of anything that seemed too much like mob rule, that is, giving too much direct power to the uneducated masses. And the third principle is checks and balances, or the separation of powers. The powers of the federal government under the U.S. Constitution are split between three main branches in order to guarantee that no single branch, or especially no single individual, even a popularly elected one, can have complete authority over the federal government. So we have three branches: the legislative branch for writing the laws, the executive branch for enforcing the laws, and the judicial branch for interpreting the laws and assessing whether the executive branch is fairly enforcing the laws. The founders of the Constitution were aware of the problems that other previous representative governments have had, such as the Roman Republic. The founders knew that people can break promises and voters can sometimes make short-sighted decisions that they later regret. The principle of checks and balances means that the federal government will only change its policies in a fundamental way if there is a determined and sustained effort from voters to elect new people into the legislative and executive branches, and if these people, in turn, are in power for long enough to appoint new Supreme Court justices. So let's look at each of these branches, starting with Article 1, which looks at the legislative branch, known as Congress. And Congress is split up into two separate sub-branches, or two houses. First of all, the House of Representatives. These representatives serve 2-year terms. They're re-elected every 2 years or have to face re-election. They're directly elected by voters. The number of representatives is decided for each state according to the population of states. So more populated states have more representatives. As far as eligibility goes, you have to be 25 years old, current resident of the state, and citizen for 7 years. And one special ability of representatives in the House of Representatives is they can impeach the President of the United States with a simple majority vote for whatever they deem to be high crimes and misdemeanors. Now note that impeachment does not mean the President is automatically removed from office. That means the President then faces a trial in the Senate to determine whether the President shall be found guilty of the articles of impeachment. In other words, to convict the President. But even that technically only removes the President from office and optionally can disqualify the impeached and convicted President from holding any public office in the future. The President will then have to face a separate trial as a regular civilian in order to put more criminal penalties on the President. But in any case, the Senate does have the authority then to convict the President, but it needs a 2/3 majority to do that. It's a safeguard against removing presidents all the time, willy-nilly, and upsetting government, making things chaotic. The Senate also has longer terms, 6-year terms, and originally they were appointed by state legislatures, not by voters, until later in the 17th Amendment in 1913 did make them directly elected by voters, but this came later. First they were just appointed. And there are 2 senators for each state, unlike with the representatives where there are more for larger states. In the Senate, every state, small states like Wyoming, big states like California, all just get 2 senators. And eligibility is a little more strict. You have to be 30 years old, current resident of the state where you're running, and a citizen for 9 years. And as far as rules of procedure for Congress, majority of total members need to be present for a quorum, which means that they can actually make binding votes. Otherwise, they can just talk, but they can't actually make any decisions without that quorum. And members of each house could be expelled for disorderly behavior with a 2/3 vote among their house. While they're in office, they have immunity from civil lawsuits, but not major criminal laws. So unlike the President, they can be prosecuted for breaking federal criminal laws. It says, they shall in all cases except treason, felony, and breach of the peace be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. So to make sure they have more, they can really speak their mind and not worry about, accidentally offending someone. They have a little more extra protection, but if they do something seriously criminally wrong, they can still be held liable. Bills need a majority of approval in order to pass, as long as they have the President's consent. But if the President vetoes bills, bills need a 2/3 majority to override the President's veto. And then what can they do? Well, they can basically handle taxes, to fund the government, borrowing to fund the government. By the way, with taxes, originally this did not include direct income taxes. Originally it just meant things like tariffs, taxes on imports. Direct income taxes later became possible under the 16th Amendment in the early 1900s, but originally the Constitution forbade direct income taxes. The government could also get money from borrowing. And then, of course, Congress decides on how to spend these funds. This expenditures must be made public. No secret budgets are supposed to be allowed, which the CIA has been accused of using at times. Regulating commerce is another duty authorized by the Commerce Clause, which says that Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And of course, some have argued that this Commerce Clause has been interpreted loosely in order to allow many more regulations of business than the original founders would have foreseen, such as environmental and labor regulations. It's up for debate on that, and whether that's even relevant in the first place, what the founders intended. Defining citizenship requirements, regulating bankruptcies, establishing money, weights, and measures, establishing post offices, establishing copyrights, declaring war. That's technically a duty of Congress, not the president, and raising and funding the armies for 2-year spans at a time. And Congress can call up state militias to put down rebellions or fight foreign invaders. Generally, the president is the commander-in-chief who actually oversees the deployment of military forces on a daily basis. Congress does not micromanage the military. Congress just declares war and basically decides on what the mission is, but then it's up to the president to execute that mission, to accomplish it in whichever way he or she sees fit. Federal Congress is explicitly barred from doing these sorts of things, such as denying writs of habeas corpus, meaning you have to charge people with a crime, can't just arrest them. No judging guilty without trial, similar sort of thing. These were called bills of attainder under the British Empire, which colonists hated, but the U.S. was not supposed to do this under the Constitution. Cannot make things illegal after the fact. No ex post facto laws. No direct taxes on individuals at first, revised by the 16th Amendment. No taxes on exports. No privileging one state's trade over another state's trade with unequal tariff rates. If you're going to put tariffs on imports, taxes on imports, it's got to be the same regardless of the port of entry across the U.S. And no granting titles of nobility. State governments can't do these things. Enter into diplomatic arrangements with foreign powers. That's only what federal Congress is allowed to agree to. Coin money. Only federal Congress can authorize that. And of course, pass bills of attainder, ex post facto laws. Neither states nor federal Congress can do this. Grant titles of nobility. Neither states nor federal Congress can do that. States cannot put taxes on imports or exports except by permission of National Congress. Individual states cannot keep troops or ships in times of peace without permission of federal Congress. And states cannot enforce or enact any legislation that conflicts with the Constitution or federal legislation for that matter, so-called Supremacy Clause. So that's the legislative branch. Article 2 deals with the executive branch, which is the president and his or her administration to then enforce these laws. For electing the president must be a natural-born citizen, meaning a citizen from birth, not just a citizen, who acquires citizenship, which has become a point of tension at times, with some people saying Barack Obama wasn't a citizen from birth. Namely, Donald Trump used to say that. And then the president must be 35 years old and a current resident in the U.S. And the president is technically not really directly elected by voters even today, elected by the Electoral College. Although in most states, the Electoral College is forced to heed the popular vote in that state. So kind of indirectly speaking, for the most part nowadays, the president is elected by voters, but not directly. And there are still many times when the Electoral College vote conflicts with the popular vote across the country. In any case, the president serves 4-year terms, and the vice president takes over in case of death or incapacitation. This became a controversy with Woodrow Wilson in his last year when he'd had a stroke and was teetering on his deathbed, and some people felt like his wife was running the country unelected. So now, president is deemed to be incapacitated. You know, and the vice president would take over. And there's some gray area of how you determine that. Some people have said Trump, based on things he said, seems a bit mentally incapacitated at times, but it's up for debate, right? And duties of the president are to be commander-in-chief of the armed forces, basically to carry out the mission assigned by Congress, draft treaties, but needs 2/3 of the Senate to approve, nominate judicial and cabinet appointments with the consent of the Senate, make temporary appointments if the Senate is in recess, and faithfully execute the laws, whatever that means, right? Very up for debate, very subjective, and have a yearly State of the Union address. So that's what the president does. Sounds simple in theory, but what does faithfully execute the laws mean? You know, that's a very broad area of debate. Article 3 is the Judicial Branch. Judges are nominated by the president and confirmed by the Senate, shall hold their offices during good behavior, meaning for as long as they live and they have good behavior, whatever that means. Once again, very subjective. And the Constitution mentions, at the very least, a Supreme Court, plus more local inferior courts as deemed necessary by Congress, however many sub-levels they want to create. And then duties are to provide citizens with the right to a trial by jury when accused of a federal crime, and the right to assess the constitutionality of federal and state laws and foreign treaties. This is technically an implied power in the Constitution, which had to be explicitly clarified in an early Supreme Court case, Marbury versus Madison. Article 4 is a couple of miscellaneous items. You can extradite people across state lines within the U.S. if they try to flee one state's laws, if they try to flee justice to another state within the U.S. States had to return fugitive slaves across state lines, although this became irrelevant after the 13th Amendment that ended slavery. And federal Congress regulates the creation of new lands and the administration of non-state territories like Puerto Rico. Article 5 has to do with how to amend the Constitution. Amendments can be added to the Constitution with a 2/3 vote in both houses of Congress and ratification by 3/4 of states, either through state legislatures voting on it or state conventions. Basically a simple majority in each state, but 3/4 of the states have to sign on. It's a pretty high bar, pretty difficult to get amendments to the Constitution. Article 6 basically clarifies that the federal Congress has supremacy over the state governments, meaning, well, at the time this implied, one, that the U.S. government under the Constitution promised to honor debts from the U.S. government under the Articles of Confederation. This isn't relevant anymore, but more importantly, it clarified that the Constitution was the supreme law of the land, which takes precedence if state laws conflict with federal laws. Or if state laws conflict with the Constitution. Basically, it's Constitution above everything, and then federal laws, and then state laws. Article 7 had to do with ratification. It needed 9 states to ratify it originally to go into effect, and then later states could join as well. By 1790, they did. All of them, all of the original 13 states. And in this ratification process, you had 2 main factions, which you don't really need to know a lot about for the purposes of this course. Just that there was one faction that wanted immediate ratification and a stronger central government, namely the Federalists. And then you had the Anti-Federalists, who were afraid of the stronger central government that would be brought about by the Constitution, compared to the Articles of Confederation, which had a very weak central government for the U.S. And these Anti-Federalists wanted a Bill of Rights promised before they would agree to the new Constitution. So the Federalists grudgingly agreed to a Bill of Rights that would be immediately added to the Constitution as soon as the Constitution was put into effect. And they fulfilled this promise pretty much the very next year after The last few states agreed to the Constitution. The states ratified these first 10 amendments to the Constitution, which became known as the Bill of Rights. The First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This has been summarized as like the separation of church and state. Or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. But, for example, the Supreme Court in Schenck versus the U.S. argued that this did not protect a right to shout fire in a crowded theater or speak in such a way that might bring imminent danger to people, such as by calling on Americans to disobey the military draft during World War I. So there can be restrictions on freedom of speech if that speech presents a clear and present danger to Americans. That's at least according to this case in the Supreme Court. Still hotly debated whether the Supreme Court should stay with this decision. Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, number of questions. What does the first clause about a well-regulated militia mean? And what do arms mean? What kind of weapons are we talking about here? You know, rocket launchers, tanks, you know, anything that's handheld, you can carry in your arms, you know. What about a suitcase nuke, you know? It's world has changed a lot since the times of the Founding Fathers, and there's arguably a gray area in here that's up for debate. The Third Amendment says, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, except in a manner to be prescribed by law. By quartered, they mean housed. And this was inspired by colonists who were frustrated with the British Quartering Act before the American Revolution, where Britain would force colonists to house British soldiers. Let's see. The Fourth Amendment is the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. No warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. One question you might ponder for yourself is, do the U.S. government's modern internet surveillance powers comply with this? Do they have warrants for everything that they collect? Do these warrants describe the place to be searched and the things that they are looking for? Think about it. Then we have the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against yourself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. And probably the most important part of this is the right to stay silent and not have to self-incriminate in a trial or when being questioned by the police before a trial. And this particular lawyer explains why this is very important here. If you're curious about this and want to go into more detail, there's some very good reasons why many lawyers recommend just not talking to the police at all in any case whatsoever, even if you are innocent of a crime, and exercising that right to stay silent and plead the Fifth, right? The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Seventh Amendment, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States other than according to the rules of the common law. So common law has to do with lawsuits between individuals. It's a situation where the government doesn't really think a person has committed a crime, but other individuals can allege that you've violated a contract, and they can initiate what's called a civil lawsuit or a common law lawsuit, where they sue you for damages, where the penalties don't involve getting in prison, but usually just having to pay a fine to a person for compensation. The Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Ninth Amendment, this basically means there might be other rights, but this is a minimum listing of the rights citizens have. There could be others in the future. And the 10th Amendment says basically by default, as long as the Constitution doesn't say the federal government has the right to do something or has authority over some area, by default we should assume that state governments or individuals have authority over that area and not the federal government. So that is the U.S. Constitution and the Bill of Rights, which you will have questions on for your weekly quiz this week. So good luck with that. There is a short little discussion forum prompt where you're going to look at some landmark important Supreme Court cases in interpreting the Constitution, and it'll be up to you to decide which of those you think have been the most important, most impactful in our history. So good luck with that, and everyone have a great week.